From the sky, the picture is idyllic, but on the ground, life in Napier Barracks is a very different story. Last September, this disused army barracks in Kent was relaunched as emergency accommodation for those seeking asylum. It was supposed to be their safe space from the pandemic. This was the reality. Inhabitants in close quarters during an outbreak. Public Health England advised the Home Office against a multi-occupancy dorm like this, but the site was actioned. The outcome was half the population here contracting COVID. Inspections found poor facilities and safety concerns. Those at high risk of self-harm were placed in isolation blocks, considered unfit for habitation. Today, the High Court said it failed to meet the minimum standard and that the Home Office acted unlawfully. In response, the government said,
"It is disappointing that this judgment was reached on the basis of the site prior to the significant improvement works which have taken place in difficult circumstances. Napier will continue to operate and provide safe and secure accommodation. We will carefully consider the ruling and our next steps."
My worry about it is that there are still 250 asylum seekers in the barracks who are suffering those conditions, and 3 of them seem to be under 18. So people who are children are being sent to the barracks. People who have been tortured are still being sent to the barracks. And so are people who've been trafficked to the UK, which is against the Home Office's own rules about who should be sent there. Sending people to horrible accommodation doesn't stop people crossing the channel. What stops people crossing the channel is a safe route to claim asylum.
it was small numbers of boat crossings that first led to the maligned plans. Concerns were raised even before a fire broke out here in January. We spoke to one man who told us that conditions here brought back memories of being tortured in Yemen. And Jason Asfar got a concerned call from family abroad asking him to mount a rescue of a resident at the camp.
When I first saw him physically, he looked sick. Actually, he had fever and he was not well, and it was a terrible situation inside the camp, and water pipe broken basically, and there were beds next to each other, and just maybe one toilet for the entire people. No hygienic. People were there without masks.
Today's judgment follows the alarm raised by inspection reports and residents. And although it leaves the government facing condemnation and compensation claims, the Home Office refused to shut down the site.
Simeon Brown reporting. Well, I'm joined now by the Labour MP, Yvette Cooper, who's the chair of the Commons Home Affairs Select Committee. Yvette Cooper, by any standards, this is a very damning judgment today, isn't it?
It is. Good evening. It's a very damning judgment from the court. What it shows is that the Home Office made a highly irresponsible decision to put people into dormitory accommodation in the middle of a pandemic, in the middle of the COVID crisis, and that they were clearly advised not to. They were given clear public health advice about the risks, both from dormitory accommodation and from the way in which they were running Napier Barracks. Then there was an outbreak. There was an outbreak of around 200 cases, and the court has been very clear that that was inevitable, given the decisions that the Home Office had taken. I think that was highly irresponsible.
I mean, the Home Office say this was during the absolute height of the pandemic, and it was to make sure asylum seekers were not left destitute. Additional accommodation had to be found at extremely short notice. That is a fair point, isn't it?
Well, this is around September time. The court judgment is clear that people were in fact being moved from other accommodation, be that initial accommodation, institutional accommodation, or different kinds of accommodation that people were in to start with. And I think you have to bear in mind that other organisations were having to take these kinds of decisions all through that period, actually at an earlier period during the peak of the COVID crisis. And they were making responsible decisions and not putting people into unsafe dormitories. So, for example, local authorities were having to find housing for people who were homeless. For example, other organisations were having to deal with the closure of hostels or of institutional accommodation. If other organisations could do it, Why couldn't the Home Office?
I mean,
Why did they
campaigners...
insist on putting 12 to 14 people into a room and having over 20 people sharing bathrooms, sharing basic facilities?
Campaigners say now they want the barracks closed down. Do you agree with them?
Well, I think we don't currently know how the barracks is being run. We haven't got any transparency on whether they are meeting proper standards. So I am deeply concerned about what is happening.
I mean, is that a failure of your committee?
Sorry?
Is that a failure of your committee that you don't know this current situation now, given how grave this problem has been?
Well, I think it's a serious problem that the Home Office is refusing to answer questions. We have been asking repeatedly for the public health guidance, for example, that was given to the Home Office back in September. The Home Secretary and the Permanent Secretary both told us that they were following public health guidance at every stage and every step along the way. And this court judgment shows that, in fact, there weren't. So we have serious concerns about the information that was given to our committee being wrong. And that is why the committee has asked the Home Secretary and the Permanent Secretary to come back before the committee and to answer, to explain the decisions that they took that were so irresponsible, but also to actually explain why the information that they gave to the committee was wrong.
But what in truth can your committee actually do? You are quite right. You know, Priti Patel, the Home Secretary, said at the time the barracks were being run all based on social distancing and COVID-compliant measures, all working in line with public health guidance. Today, the judge said that simply wasn't true. Your committee has been misled, but what can you do about that?
Well, our committee is a scrutiny committee, and that is why we have called the Home Secretary and the Permanent Secretary to come back before us in order for us to be able to put exactly these points to the Home Secretary. But I think, look, there is a wider issue here about the Home Office. The Home Office has told us repeatedly that they've learnt the lessons from the Windrush scandal, that they've learnt the lessons about needing to make sure that they do things in a sensible way and in a humane way. And instead, even though they were given clear public health guidance about these dormitories not being appropriate during a pandemic, they ignored that guidance and they continued anyway.
But just to be clear, what sanction can you or anyone else bring to bear against the Home Office for misleading the committee?
Well, the court obviously does, as we understand it, does mean that there may be potential sanctions on the Home Office as a result of this court judgment, but the Home Office should never have got into this position in the first place. But look, our role as a parliamentary committee is simply to put the questions and to put the challenges. But what we need is the Home Office to respond in a sensible way to asylum accommodation, in a sensible way to the COVID pandemic. Bear in mind, this didn't just affect residents, it also affected staff, it affected the local community, and it was irresponsible to end up with an outbreak of 200 cases, which could have been prevented if they had followed proper public health advice.
And of course, they failed to do that. I should say the Home Office say the judgment is disappointing in that it covers the period before improvements were made. But Yvette Cooper, I'll have to leave it there. Thanks very much for talking to us today.